Good morning, good afternoon, everyone. This is Eric Paley, and on behalf of my colleagues, Tom McCord, Damian Myers, Yelena Gray, and Matthew Codert, I want to welcome you all to our complimentary National Employee Benefits Briefing. Before we dive in and I hand the baton over to the speakers, I'd like to share a few housekeeping items with you. First of all, know that today's call is being recorded, and after the program, we'll be distributing a link so that you can listen to this again and again and again to your heart's content. You can send questions to the presenters online during the program. On the bottom of your screen, you'll see a Q&A box. Just type your questions into the box and submit them, and we'll see them. We'll do our best to answer those questions during the program, though candidly, there's a lot of material to get through, and we want to be respectful of your time. So if for some reason we can't answer your question during the program, we will be following up with you after the fact. So appreciate your interest and engagement there. For any of you who are seeking continuing education credits, the evaluation form and certificate of attendance form are going to be available for download at the end of the presentation. And at that time, I'm also going to mention the super secret CLE verification code that you need to write down to actually get the credit for the webinar. Just follow the instructions and return the completed documents to us, and we will take care of the rest and send back your certificate. If you experience technical difficulties of any kind during the program, just use the Q&A box to alert us, and the elves will make sure that everything gets back on track for you. Today's session, let's turn to the agenda. We'll address important employee benefits issues facing employers today. To start things off, Tom and Damian will discuss the CARES Act, relevant pandemic-related regulatory pronouncements, and offer a general discussion about how workforce decisions impact benefits programs. After that, they'll turn things over to Yelena, who will tackle the new electronic disclosure regulations that were finalized recently. Matthew will then follow things up with an update on all the important litigation going on in the space right now. And there is certainly a lot of it over the past several months. And then finally, Yelena will round things out with some quick hit updates on a number of late developing topics. Again, we want to try to stay on schedule as best we can because we want to be sensitive to your time, particularly for those of you who've got banana bread in the oven. So with that, let me turn things over to Tom and Damian. And Tom, I know you're going first, so have at.
Thank you, Eric. Damian and I are going to discuss briefly with you some new statutory and then regulatory provisions that were specifically aimed at providing forms of relief related to the pandemic. And we're going to start with a couple of statutory changes so we can move to the opening slide here. There's two major statutes so far. One is the Family First Coronavirus Response Act, and the other is the CARES Act. The Families First Act is the act that you may be familiar with that provided for a requirement that employers of roughly between 50 and 500 employees provide paid leave for certain employees affected by the virus, but also provided tax credit to pay for that leave. We are not going to focus or discuss that particular statute in this presentation. Our website does have additional information on that, but if you do have questions, you can send us an email or to let us know, and we would try and follow up or get you information separately. Rather, we're going to focus mostly on retirement and some health and welfare plan relief provisions coming out of the CARES Act. So with the next slide, we'll start the CARES Act. The major change that has gotten a lot of press are provisions related to plan distributions and loans, special provisions related to retirement plan, plan distributions, and loans. These are optional provisions. Employers don't have to adopt them. I think our experience is that a majority, and maybe a significant majority of employers have adopted the distribution provisions. A lesser number have adopted the loan provisions, particularly, however, those employers who had workforces that were more dramatically affected by the virus or by the economic downturn resulting from that. Namely, employers that have had a lot of furloughs or layoffs are being more likely to adopt these provisions. And these provisions are at this time still available for adoption. The distribution provisions basically allow employees to take distributions, including in-service distributions from defined contribution plans of up to $100,000. And those distributions would get favorable tax treatment in a couple of ways. First, taxes, they would not be subject to early distribution tax. Second, the tax that individuals pay, they can elect to pay that in 3 annual installments, not all in 1 year. And third, there's a ability to repay that distribution if they subsequently have funds available to do that, and so mitigate their tax burden even further. And you've seen if you're on our distribution list for our benefits alerts, considerable amount of information concerning this. Most recently, what the IRS has done is it's defined or expanded the group of participants who would be eligible to avail themselves if a plan adopts the provision to avail themselves of this relief. Originally, only employees who were themselves affected by the economic fallout from the virus. That is, they either got the virus themselves, had a family member who got the virus, or they themselves had a adverse economic impact. The IRS has subsequently made clear that the eligible individuals include participants who themselves may not have incurred the virus or incurred a layoff or reduction in hours, but who have had a spouse or someone who shares their principal residence has had adverse financial consequences. So this is a broader group, and I would say that if you previously adopted the relief provisions, you could consider a follow-up communication to your participants indicating that there has been an expanded eligibility for this. I will say also was initially a lot of concern about how many participants would avail themselves of this distribution feature. I think our experience has been that there's been perhaps moderate, I would characterize, usage of this provision. Again, more so in situations where employees did suffer a furlough or layoff, but it hasn't been a complete rush to the bank to take advantage of the distribution provisions. The other coronavirus-related Retirement Act provision I want to mention is loans, and that's on the next slide. Plan loans, the availability of them has been increased in terms of amount from $50,000 to $100,000, and from 50% of an account to 100% of an account, as well as a temporary 1-year repayment suspension. This doesn't get you completely off the hook for that repayment. The loan has to be re-amortized after the end of that 1-year suspension period. But for individuals who might have a temporary furlough, loss of employment, or reduction in pay, the loan provision, repayment provision suspension can be useful. This is only available through September 22nd. So if you've not already adopted, but for some reason are thinking about adopting it, time is running short on that provision. And as I mentioned, that provision has been adopted a little less frequently than the eligibility for the distributions. The other items that were built into the CARES Act, I think, are less dramatic. I would note that although plans will need to be amended if they're adopting these distribution or loan suspension provisions, there are years in the future to do that. Some plans may amend earlier than that, but you do not have to amend before adopting the provision. The CARES Act also has a temporary suspension for this year of required minimum distributions. This applies to defined contribution plans, and it really impacts people who are former employees who have already reached age 70 and a half but still have money in your plan. And record keepers are really taking the steps to implement that suspension. If you have a defined benefit pension plan, There's been some changes to the funding requirements, some relief, including a plan contribution deadline extension. You should be working directly with your plan actuary to discuss the impacts of those changes to funding requirements and whether there's anything you want to take advantage of in this relief for your defined benefit plan. I think we could move to the next slide. And there's been two other regulatory relief recently in the last several weeks that I would mention. First, with respect to the need to get notarized documents, particularly spousal consent, that was particularly in the height of the pandemic, or the prior height of the pandemic, could be very challenging for a participant to get a document notarized because you had to actually be physically present with the notary to get that document notarized. The IRS has provided temporary relief from that physical presence requirement. Now, in some cases, in some geographic areas, it's a little easier now to get those notarizations in person, but where that's still not practical or desirable, there is some relief. There's some pretty rigid requirements, some details to go through to get that. So if you have participants or availing themselves of this and you need additional information, we'd be happy to go over the requirements. There's sometimes a little variation by state with respect to that. The other item that I wanted to mention is with regard to safe harbor 401k plans. If you have a plan in which you had committed at the beginning of the year to make either a minimum 3% of compensation contribution for all participants or a minimum matching contribution in order to avoid non-discrimination testing, typically there were very limited bases on which you could, after having made that commitment at the beginning of the year, opt out of those safe harbor contributions or suspend them. The IRS has granted additional relief for making changes to suspend or reduce safe harbor 401k matching contributions or non-elective contributions. These special relief is only available through this month, August 31st. So if you are still thinking about doing this, this is something to look at now in the next coming weeks. What's been suspended is the normal requirement that a company show that it was operating at an economic loss, or that it had in fact provided special advance notice in its safe harbor notice before the beginning of the year that it retained the right to suspend or reduce the safe harbor contribution. And it also modifies the usual 30-day advance notice requirement. It doesn't eliminate it, but it modifies it. So if you have a safe harbor plan and you've not previously modified or reduced or suspended your required contribution, there's an opportunity to do so now on a easier basis, but you need to act this month. So with that, I'm going to turn it over to Damien, who is going to take up some CARES Act health and welfare plan provisions.
Thanks, Tom. So the CARES Act also contained a lot of changes to typical health and welfare plan administration. And the first major change, which started with the Families First Act, was the coverage of COVID-19 testing, which is very important given the pandemic, without cost sharing. So that basically means that health plans have to cover it without a copay, without applying a deductible or coinsurance. Now, what the CARES Act does is it clarifies when those tests and what types of tests need to be covered without cost sharing. And those are tests that are FDA approved, ordered by a doctor. There's also later guidance has also said that in-home testing would have to be covered with no cost sharing. However, importantly, testing that is done in connection with workplace admittance, such as medical surveillance, you're giving a test before people come into work, that does not have to be covered without cost sharing. So that you could apply cost sharing to. And then this applies to in-network services and also out-of-network services. And the CARES Act clarifies what those reimbursement rates are. In the in-network context, the reimbursement rate is going to be what the negotiated rate is in connection with the provider contract. In the out-of-network situation, It's going to be whatever's agreed to between the plan administrator, and the out-of-network provider, or if there is no agreement in place, it's going to be what's publicly posted on their website as the charge. So in addition to COVID-19 testing, the CARES Act also requires accelerated treatment of vaccines and preventive care related to coronavirus as under the ACA preventive care services, which means that there can't be any cost sharing applied to that. In the normal situation, when the United States Preventive Services Task Force determines that a service or a vaccine gets an A or a B rating, then it needs to be covered with no cost sharing at the 1-year anniversary, the first plan year after the 12-month anniversary of that designation as an A or B rating. Now it needs to be done much quicker. I believe it's 60 days, if not 30 days. So the whole idea here is to make sure that vaccines and preventive services related to coronavirus are covered as soon as possible once these services are developed. Another important change, given the fact that a lot of people can't go out to doctors or couldn't go out to doctors for a while and get elective care services or just go to their primary care doctors, is telehealth and high deductible health plans. Prior to this, the CARES Act, telehealth couldn't be provided for non-preventive services through a high deductible health plan until the statutory minimum deductible was met, unless the person was paying the patient was paying the fair market value of the telehealth services. Well, now telehealth, for any reason, is covered. You can cover it under a high deductible health plan without then meeting the statutory minimum deductible. So a lot of employers can provide telehealth for free or provide just a simple co-payment that doesn't necessarily reflect the fair market value of the services. A permanent change is the removal of the ACA restriction on over-the-counter drug reimbursements from medical flexible spending accounts, health reimbursement accounts, and health savings accounts. And when the ACA was adopted, over-the-counter drugs were no longer allowed to be reimbursed under these plans unless it was insulin. So now, with that restriction gone, plans can now reimburse for those types of services, which is, certainly something that's going to be helpful for a lot of people. They're going to be able to use their FSA money, for example, that they elected and contributed to, some of which they may not have been able to use as expected because of the coronavirus situation. So that's going to be a very helpful development going forward. The HIPAA privacy requirements, what we've seen there is a relaxation of the rules. Now, this is temporary, but it's possible that the Department of Health and Human Services will put out some regulations that clarify or that permanently relax the rules. Telehealth is permitted provided that the platform on which the telehealth is provided meets strict data security requirements. Now, this doesn't include a telephone. It doesn't include FaceTime on your iPhone or any like Zoom or anything like that. But the rules right now are relaxed to allow those types of services to be provided from your primary care doctor and to you so that there's access and easier access to these doctors where you couldn't necessarily go to a doctor's office or a brick and mortar building because of the coronavirus situation. And it's possible this is a game changer going forward as doctors are realizing that this is an easier way to provide care. But we'll have to wait to see what the Department of Health and Human Services does. But for now, during the crisis, this is still permitted through telephone calls, FaceTime, Zoom meetings with physicians. That's still permitted. A final thing that's worth mentioning with respect to the CARES Act is the student loan repayments. Employers are allowed to provide educational assistance up to $5,250 a year. That's excluded from an employee's income. But previously, you couldn't pay student loans for employees. Now, through the end of this year, through the end of 2020, employers can directly pay for employee student loans up to $5,250 or pay that amount to the employee so that they can then pay the student loans. Okay, so the next slide, we'll talk about some important cafeteria plan changes that came out in guidance after the CARES Act. Now, to set the stage for this, keep in mind that people on calendar year plans, individuals make elections under the cafeteria plans and the FSAs prior to the start of the year. So if we go back to open enrollment that happened in 2019, we're talking September, November, December. The bottom hadn't fallen out yet. So a lot of people made elections on their FSAs or enrolled in plans with the understanding that they would be getting certain types of care. they would have certain medical needs going into 2020. Well, all that changed when things shut down. All of a sudden, people were contributing to FSAs more than what they needed to because they can't go get the care that they expected, or perhaps they were enrolled in plans that had cost-sharing designs that wasn't necessarily aligned with what their medical needs are because of the changing situation. So what this guidance does is it allows mid-year election changes, notwithstanding the already existing mid-year election changes for things like birth of a child, adoption, loss of coverage. These, any reason, if they are adopted, an employee can make an election change for any reason as long as it's in one of these 5 categories. The first that they are able to do is make a prospective election following their initial denial or election not to enroll in coverage. So if somebody during an open enrollment decided not to enroll in the health plan, they can now get into the employer's health plan. A second one is to move from one coverage option to another coverage option. Suppose that the person enrolled in a PPO that was a low plan, meaning that the deductibles were low and therefore they didn't have to pay that much, but now they don't need that level of coverage, so they want to move to an option where the deductibles are higher, probably has a cheaper premium. They can do that. They can also revoke coverage as long as they attest that they're going to immediately enroll in other coverage. So maybe the employer's plan isn't right for them anymore, or they want to move to their spouse's plan or move to the exchange. They can do that provided that they just attest that they're going to immediately enroll in that coverage. You don't need the substantiation, but what they just need to do is get a written attestation that they're going to do that. With respect to FSA elections, you can allow, the FSA plan can allow these changes that you can reduce or stop making FSA contributions, or you can increase the amount of contribution and make it to the FSA election. Now, employers that are designing these options or that are amending their plans to accommodate this should keep in mind that you probably don't want to allow an election change for somebody who's already overspent their election. What that basically means is that if somebody's overspent, maybe they can reduce their election, but not below what they've already spent. So therefore, they still might have to make a contribution going forward. It just might be less than what it otherwise would have been. And then under dependent care FSAs, you can also make these similar elections. And this one for dependent care FSAs is a little bit less necessary because the current rules regarding election changes for dependent care FSAs already kind of allow people an out when there's a significant change in the expected cost. So if the summer camp, is canceled or daycare is closed, you're already able to make the election change to stop making those contributions. But once something is in the plan, you can't get it out. So if somebody had already contributed a lot, there's not much they can do at that point. A couple important things to note here. Employers that adopt these changes have to amend their plan by the end of 2021. And so you have some time to make the to actually amend the plan documents to accommodate these. And the second thing to note here is that this is optional. And employers do not need to do this at all. And there might be some reasons why you might want to do it, but at the end of the day, they are optional. And in my experience, I've seen kind of a 50-50 take rate on this with employers. Some employers are doing it, some employers are not. Almost no employers that I've talked to are doing all of these. They're doing maybe limited amounts, like for example, FSA election changes, but only to reduce them, not increase them. So you can put restrictions on these in any way that you want to. Okay, so we'll go to the next slide. The guidance that issued the cafeteria plan and FSA changes also contains some clarifications and some additional relief. One of the big additional changes is that the grace period under an FSA, which is the 2.5-month period at the end of a year where you can apply new claims to old contributions. So for example, if you have money left over in 2019, you can use that money to get reimbursement for claims incurred in 2020 up to March 15th. What the IRS has done is they've extended that for 2020 only. They've extended that March 15th deadline through the end of the year, through the end of 2022. So I'm sorry, through the end of 2020. So if there's any money left over at 2019, they can use that money for claims incurred in 2020. The utility here of this particular change is low, given that people made their 2019 elections and nothing really impacted those elections. So whether they had a carryover or not, or unused balance really wasn't impacted by the coronavirus crisis. Now there's a lot of people who might have contributed money to an FSA in 2020 that would love to carry that over to a next year and have an extended grace period because they may have over contributed this year. We don't have guidance from the IRS that permits that yet, but I will say that this third round of stimulus that's being debated in Congress right now does contain an extension through 2021. So that would be much more useful if that aspect of the stimulus bill is included. It'll just be a continuation of this program. We should also note that grace periods cannot be offered in connection with carryovers. You can carry over $500 a year, but under the special release, you can. You can have a carryover and an extended grace period just for 2020, and we'll see if that gets extended with later guidance or legislation. Other changes, the FSA carryover limit that I just mentioned, it's been static at 500 since it was adopted in 2014. It is now going to be indexed for inflation. So for 2020, the amount that can be carried over into 2021 will be $550, and then in later years, it'll be indexed for inflation. High deductible health plans and COVID-19 testing. I just mentioned that testing can be covered, first dollar coverage, no cost sharing under high deductible health plans. That's going to be that's going to be permitted through beginning 1/1/20 and later, and there's no end date on that, at least as of right now. And then for high deductible health plans and telehealth, the ability to cover that before the statutory minimum deductible is met, that's going to be permitted through the end of 2021. Absent some extension or legislation that allows that to continue. Now, premium reimbursements under HRAs, I'll just quickly mention this. This is just really a simple timing mechanism that this basically says that, for purposes of timing when a premium reimbursement is applied to an HRA, it can be when the first day of the month of the coverage, the first day of the period of coverage, or the first day that or the date that the premium is paid. What this means is that money that's held that's used to reimburse premiums can be paid in, say, 2019, but it applies to coverage in 2020. It's just a clarification that just makes the tax accounting work a little bit smoother. The next slide. Okay, so this is one thing that the CARES Act did was it allowed the Department of Labor the authority to extend deadlines under ERISA. And so with that new guidance, that's exactly what they did. Jointly with the IRS and the Department of Health and Human Services, they issued regulations that extended or put a moratorium on the application of several deadlines under ERISA. We'll go through some of those on the next slide. Okay, so here's a list of the primary ERISA-related deadlines that were applied. Most of them relate to COBRA. Now, COBRA has plenty of deadlines, whether it's the reporting a qualified event, sending the election notice, an employee making the election. All of these deadlines that are applied to COBRA are now on pause, and they're on pause for what's called the outbreak period, which is the public health emergency plus 60 days. So the public health emergency was just extended through the end of September. So the end of September will be where the current public health emergency ends, and the tack on 60 days to that, that's the outbreak period. So for right now, all of these deadlines are on pause until late November, unless it's extended again. If the public health emergency is extended again, then it adds another 90 days plus 60, so another 150 days. Okay, it's important to know that it's not just COBRA. HIPAA special enrollment rules also apply. So typical plans allow 30 to 60 days for employees to notify the employer that they got married, got divorced, had a kid, so that they can change their coverage or get people enrolled in coverage. That's on pause now, so people can come and say, look, I got married 90 days ago and I need to enroll my spouse, and plans would have to allow that. The timing periods for claims and appeals has also hit on pause, so people can submit claims late, and they still have to be adjudicated. as if they were timely filed. And then the external review guidelines under medical plans also are on pause. We'll move to the next slide. Okay, this is just an extension of that previous guidance. The Department of Labor, through the EBSA, issued its own guidance that essentially said that things that are specific to ERISA, like providing SPDs, SMMs, handling benefit claims, those you don't have to follow the timing deadlines strictly, but you're still guided by general fiduciary principles. So basically, reasonable under the circumstances. You want to make sure that people have the information that they have, and without providing some undue burden on individuals. The next slide. Okay, so with this, I think I'll pass it back over to Tom to cover a couple of things related to workplace issues before we revert back to some more health and welfare stuff.
Thanks again, Damien. Here's for basically 3 items that I want to highlight here. The first is with respect to the concept of furloughs and layoffs. Furloughed employee, the concept of furloughing employee is not a technical legal term. I think we generally treat it as someone who's on a unpaid or unpaid with cash leave of absence, but is expected to be recalled. Sometimes that's also called a layoff, but sometimes layoffs are also used as another term for a termination of employment. As is mentioned over in the far right-hand column here, in dealing with your 401k or 403b plan provider, where there's limits on the ability to make withdrawals until you have terminated employment or separated from service, you'll want to be careful as to how you are coding the status of employees. Typically a furloughed employee would not be regarded as separated, should not be given access to distributions that are otherwise conditioned on termination of employment. And so you should pay attention to how you are, your payroll codings going to your 401k or 403b plan record keeper are occurring with respect to retirement plan distribution eligibility. In the second column, with regard to benefits, particularly health insurance, life insurance, or group disability benefits, we are seeing a number of employers who, when an individual is on a furlough or other temporarily otherwise unpaid leave, allowing a continuation of benefits, employer-paid benefits in many cases. Now, normally, once a person is no longer working, a person would become ineligible for many of these insurance benefits because the programs with the insurance company have requirements for minimum hours of service, requirement that you be an active employee. We are seeing that most insurance companies are suspending that actively at work or minimum hours requirement for employers who want to take advantage of that during the current economic and health situations for at least a temporary period of time. Now, I think the important thing here, however, is if you are offering insurance continuation benefits to employees on furlough or other temporary unpaid leave, you should be confirming that eligibility with your insurance company and paying close attention to what the length of any temporary accommodation may be by insurance companies. Some of those were only through June 30, but insurance companies have expanded them further. So the key there is to start and stay in contact with your insurance company if you're providing continued insurance benefits during a furlough. On the next slide, partial plan terminations is an important consideration first for your retirement plan, and this applies when individuals have been terminated employment. Or it could also apply in the case of discontinuing employer contributions, but a temporary discontinuance or suspension of employer contribution should not trigger this. Partial plan terminations, which is a very confusing terminology, is simply a requirement that says when approximately 20% or more of employees terminate employment, separate from service within a year, that then all employees who are terminating during that period of time will need to have their accounts in the plan fully vested if they are not otherwise vested. So this applies again to retirement plans, including 401k plans. It applies to employer contributions, which have a vesting schedule, and it applies if you are having a significant, particularly a 20% or more reduction in force. So if you're having this, you would need to be working with your counsel and your record keeper to see if some people who would otherwise forfeit benefits may need to have their accounts fully vested in order to satisfy this important IRS rule. On the next slide, I think we're turning back over to Damien with some important COBRA notice updates.
Great. Thanks, Tom. So as many of you know, for many years, the Department of Labor has posted model COBRA notices on its website. And the two notices that they post on their website is what's referred to as the initial or the general COBRA notice that goes to all employees or all individuals who are first enrolled in a plan and then spouses when they become enrolled in the plan. And then the election notice, which is given to a qualified beneficiary, which is somebody who has experienced a qualifying event tied with a loss of coverage. And these notices are very helpful and they're widely used. And from time to time, the Department of Labor will update them. And the last time it did it was in connection with the Affordable Care Act. And just a few months ago, the Department of Labor updated the notices again to reflect Medicare as potentially being an alternative coverage option for some individuals and to explain the interaction to some extent between COBRA and Medicare and you know, what type of events could impact which is available. The rules are complex and then the notices can't go into every detail, but they do link to CMS websites that we're able to get people can get the information that they need. So what we would recommend is that employers who historically have used the DOL COBRA or model notices, they make sure that their notices contain the new Medicare information and that they do a thorough review to make sure that the model notices are otherwise, you know, compliant with what's available online. The reason why this is important is because the DOL has taken the position that in connection with an enforcement action or any other type of DOL investigation, use of the DOL model notices is deemed compliant with the COBRA notice requirements. The potential foot fault here is that the DOL model notices do not contain every single piece of information that's required under the COBRA notice regulations. So whereas the Department of Labor would treat the model notices as compliant, there's no guarantee that a court would when it's applying the regulations to a particular notice. And what we've seen is an uptick in litigation, which we'll talk about in just a minute, an uptick in class action litigation that's alleging that model COBRA notices, or not the model COBRA notices, but just COBRA notices in general, are either confusing or missing information that's required under the regulations. And it's triggered $1 million settlements over the last couple of years in some cases. So what we typically recommend is you start with the DOL model notices and supplement the notices with information that covers everything that's required in the regulations. That's kind of the belt and suspenders approach that employers could take to protect themselves from this litigation. Another thing to note is that a lot of employers simply rely on their third-party COBRA administrators to prepare these notices and send them out. And although there's some review requirement, they don't necessarily think that the employer is the one that's responsible for compliance. Well, the case law under COBRA is very clear that planned administrator means the employer in almost every circumstance, not third-party administrator. So in order to have the third-party administrator on the hook for compliance, you would need to have that administrative services agreement in place that passes the buck over to them, because, you know, absent that, the third-party administrator is going to simply say we're not liable. So what you would want in your administrative services agreement is an affirmative requirement that any notice that or that the TPA ensure that any notice that is used is compliant with the COBRA notice requirements, and that there's indemnification obligations in the event that there's any liability because of a faulty COBRA notice. We'll go to the next slide. So this is the COBRA litigation that I referenced a second ago. Now, COBRA litigation happens all the time, but what we're really focused on here is this class action COBRA litigation that is starting to accelerate more and more, and it's typically emanating out of Florida. There's one or two law firms that are doing it or that are driving the ship here, and basically what they're doing is they're mining for qualified beneficiaries using various resources that they have, and they're finding companies that have COBRA notices that are complex, potentially confusing, and that don't contain certain information that's required under the DOL regulations, the content regulations. And we're talking big companies at this point because these law firms are going to go after the big fish first, but it's going to keep filtering down, and this litigation is not going to go away until COBRA notices become relatively standardized and employers are making sure that the regulations are complied with. So right here, there's been more than 10 cases of this class action litigation. There's been a lot of settlements. We haven't had a court come out and say for sure that the COBRA notices are in violation of the regulations. They mostly settle because what happens, it'll go to a summary judgment proceeding, and a court, at least what we've seen, is the courts will often deny a motion for summary judgment, which means it's going to go into discovery and motion practice and potential trial. And at that point, it just makes more sense for an employer to settle, which is what we've seen so far. So the next slide is just an example of this litigation. This one's against PepsiCo. So again, it's a very large company, and it was not dismissed by the Southern District of New York. The court said it was a close call, but there's a lot of questions of fact when it comes to whether or not a COBRA notice is complying with the regulations. And because there's these questions of fact, it's typically not appropriate to dismiss at the early stage under traditional jurisprudence. So we'll see what happens here, as this litigation progresses. But I'll say that it almost seems like at least once a month we're seeing a new, class action filed against a large company and even some mid-sized companies at this point. So this isn't going to go away anytime soon. So with that, I will pass it over to you, Elena.
Thank you, Damien. We're switching from the most recent legislation related to COVID to new electronic disclosure regulations that were finalized and published in May of this year. The proposed regulations were published last year in 2019, and we can go to the next slide. That will tell us a little bit more about the regulations. So as you well know, ERISA requires several documents to be provided to participants, and administrators have to have procedures that ensure actual receipt of these documents, such as SPDs, pension funding notices, summary material modifications, and many, many other documents. And it's becoming, as you well know, very administratively burdensome and many times very expensive to do actual mailing, which also doesn't necessarily ensure that participants or beneficiaries in the plan receive these documents. And short of going to the mail, to the post office and having them all stamped, you can't even ensure even that delivery of documents. And of course, the pandemic underscores the necessity of using electronic means of providing documents to participants. And many industry organizations, practitioners have been advocating that the Department of Labor relax the rules around providing documents electronically. Previously existing safe harbors allowed electronic delivery to participants who are, quote unquote, wired at work, meaning that they are, as part of their daily duties, required to sign into their employer systems and have access to the electronic versions of documents being mailed or documents provided with a link to a website and accessing the information on the website. However, for those participants and beneficiaries that don't have daily access and are required to sign in the system, the regulations required prior consent to receipt of documents electronically. The most recent DOL guidance issued with respect to electronic requirements relaxes a lot of administrative burdens and expands the ability of employers to provide documents electronically. The regulations adopt this new alternative safe harbor notice and access. And so long as the administrators follow the requirements for these disclosures, they will comply with the ERISA requirements to have documents provided. What's very important to know is that this new alternative safe harbor applies only to retirement plans and only to documents that are required to be provided by ERISA. A plan sponsor who wants to take advantage of this safe harbor can post the documents that need to be provided on the website or on the mobile app that is designed for these purposes. And at the time that the document is provided, it notifies individuals about the document that's becoming available on the website or on the app. This procedure applies only to covered individuals, which means these are participants or beneficiaries who have provided the plan administrator with their email address. For these purposes, the employer may assign a work email address. However, this assignment has to be for employment-related purposes outside of just for delivery of ERISA documents. So employees have to have that assigned address for many other employment purposes. The procedure also covers only covered documents, which means these are documents that ERISA requires plan administrators to provide automatically and does not extend to documents that are only required to be provided upon request. For example, a plan document is not required to be provided automatically, but if a participant or beneficiary requests a plan document, it needs to be provided within 30 days. So those types of disclosures are not covered. Going to the next slide, we will see that before a plan administrator can take advantage of this new alternative notice and access safe harbor, the administrator must provide an initial paper notice that will tell the participants that the administrator decided to provide all ERISA required documents electronically and must state in that document the email address that will be used for purposes of delivery of ERISA documents, must contain the instructions on how to access the documents that will be provided electronically, must also advise participants that documents will not be available on the website indefinitely. They will remain there for at least 1 year, or if later, until they are superseded by a new version of that document. And also would have to advise participants that they have a right at any time to request a paper copy of the relevant covered document. And also they have a right to opt out of electronic delivery of all documents. Although, as we later will notice, plan administrators may provide a document-by-document waiver, but ultimately the regulations only require a global opt-out of all documents if the participant so desires. And the initial notice must advise participants on how they can exercise that right. What makes this new safe harbor a little less useful is that the initial notice must still be provided by mail in a paper form. And during the pandemic, especially those who are working remotely and have very limited access to the office, that requirement makes it a little more difficult for plan administrators to take advantage of the safe harbor now. And the next slide will take us to the centerpiece of the regulation, and that is notice of internet availability. And that is the notice that must be provided generally every time that a document is posted on the website. And the document must be posted on the website no later than the time that is required by ERISA. For example, if we have a summary of material modifications, usually the deadline for providing it is no later than 210 days after the year in which the amendment or modification to the plan was adopted and became effective. So the document still must comply with the ERISA deadline requirements. However, it can be posted on the website, but must be accompanied by a notice of internet availability that will be delivered electronically. It must contain in the subject line or a title a very specific statement, disclosures about your retirement plan, and must, in the body of the document or in the body of the notification, explain important information about your retirement plan is now available. Please review this information. It must identify the document that is being provided, and if the name of the document doesn't describe the nature of the document, then the notice of internet availability must include a brief description of the document. For example, if it's summary plan description, that speaks for itself and no additional explanation is needed. But if it's a blackout notice, then a more extended explanation of what the nature of that document is should be included in the notice of availability. There should be also a cautionary statement about the document being on the website for a limited period of time, a year or if later until superseded. It must include the internet address where the document is made available or a hyperlink. Both the address and the hyperlink must be specific enough for the participant to access the document easily. So the link must lead to the document itself, or it may lead to a logon page where as soon as the participant logs in, he will be taken to the document. There also must be a statement of the right to request a paper copy or opt out of electronic delivery and an explanation of how that right will be exercised. There also has to be a telephone number to contact the plan administrator with any questions. And as we move to the next slide, we will see that the regulations generally prohibit any extraneous content in the notice of internet availability, so as to keep it straightforward. However, it may contain a statement whether any action by participants or beneficiary is required or not required, and how to exercise the action that is required. But that statement must not be misleading and must be accurate. The notice may also contain graphics, logos, design elements. Again, they have to be accurate, not misleading, and should not obscure the main content of the notice. It also must be written as every ERISA document in a manner to be easily understood by an average participant. We move to the next slide, and we will see the requirements for a website, or as we know, a mobile application where documents would have to be stored. And the plan administrator is charged with the requirement for ensuring that the website exists. And that also means that it's available with the exceptions of some technical difficulties, some circumstances that are not within the plan administrator's control. Generally, if you look through the entire regulation, the standard for the plan administrators is ensuring reasonable procedures that would make the electronic delivery compliant with the ERISA requirements. The document that is made available electronically must be available on the website as ERISA requires, as we mentioned, by the deadline that ERISA requires. It must remain there for at least 1 year or until superseded by a new version of the document. For example, an SPD, as we know, when changes to the plan are made, an updated SPD must be provided every 5 years. If there are no changes, which is probably not very common, then every 10 years. So that's the deadline for providing the document, and the document must be there until it's superseded by a new version, but at least for 1 year. Even if the document is superseded earlier, the old document has to remain on the website for at least a year. The document must be presented in such a manner that it's easily understood by an average participant. So it shouldn't be obscure on the website. It should be fairly obvious. The document must be in a format that is appropriate for reading online and printing, which pretty much a PDF or maybe a Word version of the document that can be easily printed and read. The document must also be searchable by words, letters, and numbers, and must be presented in the format that can be retained electronically. So participants would need to be able to save them to their computer hard drive or a folder in some other manner, but they have to be capable of being retained in the electronic form. The website must protect confidentiality of personal information. Not all documentation contains such information, but for example, if you are posting quarterly statements of participants' accounts, of course you want to be, you have to make sure that information about the individual participants' investment choices, account balances, is not going to be disclosed to anyone else but the participant for whom it is intended. And if we go to the next slide, we can see that the system must also be designed in a way that it will alert the plan administrator when the email address or the number for a mobile device, internet-connected mobile device, such as smartphone, has become inoperative or invalid. This can be accomplished by a bounced back email. So there has to be a structure that will notify the participant, the plan administrator about that something has happened to the email address. It's no longer valid. Therefore, the plan administrator needs to take steps to obtain a proper address or use an alternative address that had been previously provided by the participant. Or the plan administrator can just treat the participant as having opted out and provide a paper copy in the mail or in hand delivery as an alternative until a proper address is being provided. In the event that participants whose work email address was used for delivery of ERISA documents terminates employment, the plan administrator again must either ensure that the work address is still available, which is rare, or has to take steps to obtain an alternative valid address from the plan participant or beneficiary. It is important to note that plan administrators cannot use email addresses or mobile numbers that they obtained in some other manner than directly from the participant or beneficiary or through the address assigned by the employer. They cannot use search engines to identify the address, even if it's valid, even if the document can actually be delivered. That would not be compliant with the electronic procedures under the safe harbor. Every document that is posted on the website or mobile application must be accompanied by a separate notice of internet availability. However, the regulations do allow to combine several notices, and those notices that can be combined include SPDs and those annual notices that don't require any action from a participant. The plan administrator can provide one compliant notice for 2 or more required disclosures every year, but no later than within 14 months from the prior year's notice. Of course, not all notices, not all documents can be combined in one notice, because the timing when these documents become available or must become available is not uniform among different pieces of covered documents. So the employer has to kind of think about what can be provided around the same time. Probably SPDs, SMMs, SARs could be provided at the same time, but if you have a pension funding notice, it has a different timing. So again, you have to see what you can use as a combined notice. We can move to the next slide, where we make a few observations. First of all, the regulations do still allow a true and tried method of delivery via email. In that case, the notice of internet availability isn't needed, but all the other requirements would have to be satisfied. The email subject line has to contain the same statement. The body of the email would contain the same alert about the importance of the information. Again, the advice about the paper copy, about the ability to opt out and how to exercise those rights. All of that needs to be included in the email when you are delivering a document in the body of the email or as an email attachment. Of course, you don't need to say anything about availability online for a year or longer. So mainly, most of the requirements will still need to be satisfied, and the email delivery is still a very valid method of providing documents. This safe harbor is definitely an improvement compared to the other methods of delivery that have been previously available, but there are still quite a few hoops to jump through. And at this point, the initial notice of electronic delivery, as I mentioned again, is problematic because it has to be mailed in a paper copy or hand delivered. A reminder that this new rule does not extend to disclosures required by the IRS and does not extend to welfare plans. The Department of Labor indicated that it will continue looking at the welfare plan disclosures, whether electronic delivery is appropriate. Also know that HIPAA privacy is not covered by this. So if you have a HIPAA notice of privacy practices, you have to comply with the HIPAA requirements for electronic delivery, which pretty much requires a consent of the participant. New regulations are already effective. Plan sponsors could have relied on them even earlier. What's also important that there is other sub-regulatory guidance that is still in existence. It can still be used, but for a limited period of time, for 18 months, and that period will end January 26, 2022, at which point only 2 safe harbor will exist, and that's the existing safe harbor for employees wired at work or this new notice and access safe harbor. And that is all for our electronic delivery. And with that, I will turn it over to Matt.
All right, Buck. Hello? Yeah, go ahead, Matthew. Okay, so in the Bostic versus Clayton case, this is a arguably landmark Supreme Court case where the Supreme Court consolidated 3 cases into one in order to decide under Title VII whether these employers discharging employees for their sexual orientation or gender identity was permissible under the law, because the law basically says that an employer may not actually discriminate against the individual because of their sex. In each of these cases, there was a split among the circuits, and the Supreme Court took up this appeal. Please, let's get to the meat of what the Supreme Court decided. Now, Supreme Court Gorsuch is a textualist, and within this context, all the parties agreed that the parties concede that the term sex in 1964, which is what Gorsuch loves to do, was only a biological distinction between male and female, and that he focused on that particular distinction in order to come to the conclusion that employers cannot fire a male for traits or actions that it would not have questioned in a different sex. One of the key examples is if Jane marries Jim and the employer goes out and buys Jane a card and continues to have Jane as an employee, however, decides to fire John for marrying Jim, that would be based on sex. Now, employers in this particular case tried to make the distinction that they were firing each of these individuals because of the sexual orientation or gender identification. The Supreme Court decided that an employer cannot actually avoid liability by pointing out some specific factor without actually dealing with the sex issue. So the fact is that an employer will not be able to, in the future, point out that a person has a sexual orientation, which is a characteristic that they don't identify that should be male or female, in order to discriminate under Title VII. So let's get to what you probably really want to know is, let's move back, please. Thank you. So in light of this decision, what do you really need to do? And why this is an employment decision, this does affect your employee benefits. So for instance, you should probably look at your employee practice, employee policies to make sure that they are not affected by this decision. While about half of the states within about half of the states actually already protected sexual identity and gender identity as a protected class, the other half did not. So you might actually have some provisions within your employee policies that need to be identified and changed. What probably is more importantly is your healthcare coverage may include exclusions that would affect these individuals. Within those exclusions would be an easy identifiable one would be transgender transition services might be excluded within your health plan, and that might not be acceptable under this Supreme Court case. One last thing to point out is that while Title VII, this was a Title VII case, the HHS recently finalized the ACA rules and regulations. Within that, they actually had an exception for sexual identification or sexual orientation and gender identification. That rule will likely be overturned, and primarily because the language that the Title IX uses is actually very similar to Title VII, and the regulations specifically pointed out that Title VII case law often informs Title IX case law. So they were already deferring to what Title VII would eventually rule in this case. So let's go on to the next slide. So in full, this is basically a class action where James Thole essentially sued U.S. Bank because between 2007 and 2010, U.S. Bank, through prohibited transactions, lost $750 million, quite a big number. However, Thole, through a defined benefit plan, was receiving his monthly payments, and those monthly payments never changed. And because lawsuits are, justice is a little bit slow, In 2014, while the participants were litigating, the plan came from being underfunded to being overfunded. And at that time, the defendants made a motion to the district court asking that there would be a motion dismissed because the plaintiffs in this action actually did not suffer any kind of loss. And the Supreme Court took up this issue. Please, next slide. All right. So in a 5-4 decision, the Supreme Court basically did not accept the plaintiff's argument that under common law, or actually they sort of did accept the plaintiff's argument that under common law, a beneficiary does have an interest in the assets of a trust. However, this is a defined benefit plan, and there is a standing issue. And what the Supreme Court was not willing to extend is that the common law interest in the assets of the trust would grant standing de facto. So they essentially came to the opinion that win or lose, this participant would receive the exact same amount and monthly benefit that they have always received. So if there was a breach of $750 million, it wouldn't have changed, and that breach was recovered, it wouldn't have actually changed the participant's benefit $1. They did acknowledge that the person who does have an interest and could have sued in this case in the oral argument, they did acknowledge that the person who would be best to probably maybe sue would be the actual trustee, which is pretty interesting. Now, obviously in a 5-4 decision, there was a very good dissent, and then the dissent basically pointed out the fact that the only way a plaintiff in a defined benefit action could actually sue is if the plan was substantially underfunded and that the company was on the brink of failure, which is not really that good of a ability for the plaintiffs or for the participants to protect themselves. So while this might be positive for defined benefit plans, let's move to the next slide. Oh, let's go back. So the things that you should probably think about on this is, is this kind of case, while it was defined as a defined benefit case, is this the type of case that's only going to be within the realm of defined benefits? While the Supreme Court acknowledges under a defined contribution that any loss of $750 or $750 million would actually lower the participant's actual account balance under a defined benefit, that's not actually the case. But will this case be used for maybe even the COBRA notices that Damien mentioned earlier, where plaintiffs are not always able to actually point to a specific loss? Would they be able to do a class action in that case when the Supreme Court has already come out that you actually have to have a specific loss? Another part or another idea is maybe courts or employers would be able to look at the healthcare plans and see if there's any kind of fiduciary breach in the healthcare plans that would result in some kind of loss. In that case, I think the argument would be a lot harder to say there wasn't a loss, because I think, as most of us know, that healthcare benefits change on an annual basis at the very least, and what they cover or not cover, or even the price that they charge the plan, it moves around. So maybe a participant can make the argument that they were affected at least on a minor or a small scale. So please move to the next slide. Now, this is probably the more important thing, at least in my mind, and it's cybersecurity. Now, so in each of these cases, and there are more than just these two cases, in each of these cases, the facts are somewhat the same. In the Barnett versus Albert Labs, a participant's account information was stolen, and a cyber criminal was able to get online and transfer $245,000 from this participant's account. They did this in part by continuing to call the TPA customer service representatives and essentially obtain the information necessary for them to change the password, change initiate a new transfer to a bank, add new, and because of that, this participant has a sense lost. Of course, the company and the TPA has suggested that they are not, we're not going to file a claim, or we're not going to give this person back their money. So this person filed. In the below case, it is a little more complicated in the sense that in this case, some cyber security or some cyber criminals were able to obtain a distribution form, and then they spoofed the administrator of this particular law firm. And by spoofing the law firm's email address, they sent it to the TPA and custodian, basically stealing over $400,000 of this participant's account. And in that particular case, the court essentially found that the custodian and the TPA were fiduciaries because they didn't follow their own policies. In fact, the custodian required a hard signature, or actually needed to authenticate the signatures before even making these distributions, and they failed to do that. And if you read the cases, they essentially used the exact same signature and the exact same distribution form just by changing the numbers constantly. So if someone just even paid attention slightly, they would have been able to do this. Next slide, please. So what can we learn? Well, in today's landscape, I think cybersecurity is going to be a big issue. I think a lot of us are dealing with employees who are off-site, and so cybersecurity is going to be something that is going to occur more frequently for a 401k. A lot of companies and a lot of participants sort of think of their 401k as something that they contributed to and forgotten about. I think as an employer, we should really pay attention to that particular aspect and actually educate our employers. But, what we should probably do, and maybe in the beginning, is to go back to our service provider contracts and look at how we deal with distributions and look at who's going to be responsible for the actual distribution, who's approving distributions, are there two-factor authentications being used. Go to the next slide, please. What kind of notices are we going to provide? I think for a lot of plan administrators, they are using sort of outdated, notices. I think at this point, my credit card company tells me if someone uses my credit card or if they have any kind of questions immediately, and I get a text message. Having a text message or email in addition to actually a mailing to me by U.S. Postal Service, which is probably the standard at this point, and I don't know if anybody's going to be able to not have that as the standard as these cyber litigation cases continue to go on. Last, I would like to point out there is such a thing as cybersecurity insurance, and you could, within your administrative service agreement, require that they have cybersecurity insurance, and you as a company might want to look at cybersecurity insurance. And I realize we're a couple minutes over, and I will turn it back over to Elena.
Thank you, Matthew. As Matthew said, we are a little over time. So I will just direct your attention to the list of latest developments in the last few slides. I will not go over each of the developments, but they are important enough. And if you would like us to address any of these topics in our future webinars, we would be very interested to hear from you. And in the interest of time, of course, I will not be going through them, but I would encourage you to read through the list and let us know what's of utmost interest to you.